A no contest plea, multiple victims, and a courtroom filled with tears. What should justice look like when the past and present collide inside Judge Boyd?
Okay, pause right. There are no contest plea with multiple victims involved. That's already intense, but when Judge Boyd steps in, you know things are about to get deep. Let's see how this courtroom drama unfolds.
Boyd's court.
All right, and who's here on Christopher Davis, I think? All right, if you all to come forward.
Judge, just, they're not testifying, but we do have 3 people on Zoom.
Okay. And then after Christopher Davis, it's going to be Juan Casanova and Abel Martinez. All right, court is calling 2022 CR 7283, State of Texas versus Christopher Brent Davis. I have parties announced for the record for the state. For the defense.
For Mr. Davis.
Suzanne Kramer, also for Mr. Davis.
All right. Mr. Davis, you entered a plea on May 7th of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt. You're coming open to the court. Have both parties had a chance to review the report from probation?
Yes, Judge.
Yes, Judge.
Any objection?
Quick legal check. A discharge listed as less than honorable versus general under honorable may seem minor, but in sentencing those distinctions can sway how a judge views character and credibility. Details matter big time.
State?
No, Your Honor.
Defense?
I have a couple of corrections, Judge.
Yes.
Regarding his discharge from the Navy, it was stated in there that it was less than honorable. I think his actual discharge was a general under, what's it called? Under honorable.
Okay.
General under honorable, not less than. Okay. And at the very end where he states a few things he wanted you to know, he refers to something that happened to him at age 5, but that subsequent conversation with his mother, that was determined that happened when he was at age 2.
Okay. All right. Any witnesses?
Not from the state, Your Honor. We just have an argument.
Just Mr. Davis, Judge.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do have a couple other witnesses. Can we take them first, Judge?
Sure.
Thank you. I'm sorry.
All right. Call your first
call
witness.
Edith Davis.
All right. Edith Davis.
Stand over yours.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right. You're going to need to keep your voice up so the court reporter can hear. Could you state your name for the record?
Edith Davis.
All right. Defense?
And Ms. Davis, are you Christopher's mother?
I am.
All right. And I think you may have heard me state just a minute ago about something that happened to Chris that you said happened at age 2.
Yes, sir.
And can you explain to the judge what happened and how that turned out?
So our babysitter was leaving. We were looking for a new sitter. My husband's getting ready to go to Korea. We found a lady that was in the neighborhood. She had 2 other children that were a little bit older. I had come early one day and found their children throwing rocks down on my children. Christopher was almost 3, not quite. Then when I got found out she was giving them dog feeds for cookies for their snack, and I had known that both my kids, Kristen was disabled, but Christopher, very active, had gotten very, very afraid of when I was cleaning house. I didn't understand why, but when I had talked to my...
Wow, that babysitter story is heartbreaking and it paints a clear picture of early trauma. But here's the million-dollar question. Should past abuse influence sentencing today? What do you think? Does it excuse or explain?
My daughter, she's told me that the kids would take the vacuum cleaner and suck on Christopher with it and tell him that he was going to suck him up and he would suffer. So when I saw what was going on at the house, I immediately removed him from the house. I found my next door neighbor was going to take care of them for me. So it took a little while to get him a little bit more calmed down, but it was pretty traumatic for them.
And did you have a statement that you wanted to read for the judge?
I do, if that's okay.
All right. State, do you have any objection to the reading of the statement, or would
Sure,
y'all?
okay.
Well, I mean,
I know.
it's technically it's a narrative, but if you all want her to read from it, or counsel, if you want me to read it,
I have no objection.
all right, you may proceed. That's okay. If it would, if you want to, I can actually read it.
Thank you, Judge.
All right, you're welcome. No problem. Just give me a moment. All right, any further questions?
Do you have anything else you'd like to tell the judge? Okay, nothing from Ms. Davis.
All right, thank you.
I'm going
Okay.
to call Michael Davis.
All right, Michael Davis. Does anybody have any Kleenex? All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Davis.
All right, defense.
All right, Michael, are you Christopher's father?
Yes, sir.
We've had some conversation about this.
This right here is powerful Michael Davis. Admitting one phone call could have changed everything. It's a gut punch reminder about mental health missed interventions and how easily lives can be derailed.
Scenario, and it's my understanding that you feel like maybe you could have done something different and would have avoided all this. Can you explain to the judge what you're feeling?
Yes, ADHD runs in our family. I was never diagnosed, but I've had issues with it my entire life. I'd learned to deal with it. When Christopher finished high school, he quit taking his medication. And when he joined the Navy, if I'd called the reservist office and told them that he was ADHD, because I know he didn't tell them, they would either rejected him or kept it, had him take his medication. His whole life would have been different. One phone call, if I'd made it, wouldn't be here. So, love my son. I know he did wrong, but that's all I've got, ma'am. I'm sorry.
No, I appreciate you coming in to testify.
I don't have anything further, Judge.
Any other questions? All
Thank
right,
you.
thank you so much.
And Judge, at this point, I just have Mr. Davis.
All right, so raise your right hand for me. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Christopher Brent Davis.
All right, defense.
All right, Christopher, what is it that, other than what you already stated in the PSI, what is it that you would like the judge to know before she decides what your sentence ought to be?
Your Honor, there is no explanation, there's no rhyme or reason, nothing will be able to be justified as far as what my actions did. There's every day that I live with regret because it's not only one person I hurt several people, including my own children, my own biological children. The only thing I can ask is for forgiveness from them, and I will accept whatever consequence that you see.
Here it is, courtroom climax. State wants life, defense asks for 20. Judge Boyd. He's walking a tightrope balancing pain past trauma and the scale of justice. What would you do if you were in his seat?
That is punishable, Your Honor.
All right.
And Judge, this is the part where I tell my wife, if I tell you something from here on out and that you can accept it two ways, one to make you mad and one to make you not mad, I mean the one that makes you not mad. Okay. So, question that we have is what's appropriate punishment for this type of case for Mr.
All right,
Davis?
I'm sorry, just 1 second. State, you don't have any questions, do you? All right. All right, thank you for giving your testimony. And so the range of punishment for this offense is 5 to 99 years or life.
That's correct, Judge.
So, State, what are you requesting?
Do you want my request and my argument, or just my request?
Your request.
You're asking for life, Your Honor.
All right. So they're asking for life. Defense, what are you going to be asking for?
Judge, we're asking for 20.
All right. So now, State, I understand why you're asking for life. Defense, I understand why you're asking for 20. So, one, I'm not going to sentence him to life. I've taken in consideration his testimony. I've taken in consideration the testimony from both his parents. And I want the parents to know At some point in time in life, your actions are not the cause of your child's actions. Because how old are you?
38.
All right, so he's 38. At some point in our lives, when we're making our decisions, no matter what happened in our past that was horrible for us, or maybe our parents made a mistake in how they raised us, at some point, your actions are your own. All right, so I'm not going to sentence you to life, but I'm not sentencing him to 20. It's an egregious offense.
And if I may offer some perspective on that, Judge, that's what
Yes.
I intended to do. So we agree it's egregious offense. He agrees it's an egregious offense. It's something that went on for about 6 or 8 months from what we can tell from stipulated evidence. And yet, the same day that we were pending, that we actually entered our plea, there was another person pending who's had a death of a child, injuries to a child causing death. And the very next day, this same prosecutor's office, same prosecutor,
I'm gonna object to this
offered
line of.
them 18 years.
All right, okay, so here's the thing. Defense attorneys, you all know that sometimes people can be at the Bexar County Jail or at the prison. Sometimes there are people at the prison for murder, they get 5 years. Somebody else at the prison for murder, they get 30 years. Every case is different, and there's a reason why people are given certain times. And there are reasons why sometimes this court follows a plea, sometimes that I do not follow the plea. Now, what I'm telling everybody, the state has asked for life. The state can ask for whatever they want. I've already told the state, I'm not giving him life. So the argument about what they did in other cases, that's not an appropriate argument. We're here for this. Now, if somebody wants to make an argument that the same fact scenarios, as we would call it in law school, that the case is on all fours, if there's another case that's on all fours with this case, where the state gave somebody 12 years or
Now this is where things heat up defense throwing down comparisons to another nearly identical case, but Judge Boyd isn't buying it unless it's on all fours. That's lawyer talk for nearly identical in law and fact. Smart move or courtroom gamble? Let us know below.
10 years, then we need some explanation, because maybe things are not being done fairly. So if you can present a case to the court that's on all fours with this case where the state made an offer of something less than life, I think it's relevant. I'll hear it, because maybe something else is happening in the office.
Well, Judge, and I would offer you something on that. I think it's on all fours. I don't know whether it's on all fingers and toes, but there was a case in the 227th where the fellow was charged with continuous sex abuse of a child, same as Mr. Davis. He was allowed to plead to aggravated sexual assault of a child, same as Mr. Davis, but he was given 12 years.
All right,
For a 4-year-old child.
So let me ask you this. Was that a case where you had a defendant who's alleged to have pretended to be a juvenile online and then tricked his stepdaughter into allowing him to engage in sexual activities with her by pretending if she didn't, the new friend that the defendant had created, life would be in danger?
Of course, Judge, I cannot offer you that, but they just, for selective prosecution purposes and sentencing purposes, substantial similarity, I think, is what they look for. And in this case, the same charge, same reduction, a 4-year-old instead of a 14-year-old, and this fellow gets 12 years and the state wants life. I know you said you're not giving that to them, but this guy gets 12 years in a different court, and Mr. Davis is looking at whatever that you choose to give him. So that's the only reason I'm offering that, Judge. And again, back to I'm not trying to make you mad. I don't want to visit my sins on my client.
No. Here's the thing. One, I don't get mad. I believe that everybody should be allowed their argument. I've been a defense attorney before. People should be allowed their argument. I've been a prosecutor before. People should be allowed their argument. I don't get mad. And what I can tell everybody, when you're in jury trial, if this were a jury trial, guess what? Defense counsel's state's closing arguments, that's not evidence. Evidence is the steps that I have. Evidence is whatever testimony I receive. Closing arguments that counsel do on both sides, that's spin. And hopefully the arguments they're making is in some form or fashion connected to the case that was just heard. All right, is there anything else?
No, Judge, I would just like to highlight there is one other statement from Christopher in the pre-investigation report at the very last page. It states that he was the subject of a grooming himself when he was around 12 years old by a 39-year-old. We've discussed this, and again, Judge, he's not of the opinion that is any excuse for what happened, and he doesn't even really know if it went any any substance or predisposition for him to have done this, but it's just offered for the court for contextual purposes.
All right. So I want to let you know that I heard all of the arguments. I internalized everything. And these are very difficult cases. Anytime someone comes open to the court, it's very difficult. And let me just tell you why it's difficult. This is the type of case where everybody will say automatically it's a life case. Right? But I go on facts. I go on what I read. I go on everything. I go upon, experience I've had in dealing with specific cases. Because otherwise, if every case were a life case, then guess what? We don't even need to have a punishment hearing. It's just, this is what you did. We prove it. You get life automatically. So I look at everything. What you've done, of course, is something very bad. And people are going to be impacted for years to come. Right? So sometimes when I consider what to sentence somebody to, I think about their age. I think about protecting of the public. And there are many things that I have to consider. Like, for example, is somebody going to allow you to be around children again? That's something I have to consider. Like, what age will you be where people will see you and they will not say, oh, that's a good catch. Let him babysit a child. Those are all things that I have to consider because part of my job is protecting the public. And I also have to consider evidence that's presented. I consider the stipulations that you stipulated to. So this is what the court is going to do. Court is finding you guilty. There's to be no contact with the complainant. There's to be no contact with any minor. There's to be Chapter 62 registration. Court is going to sentence you to 45 years. Court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Sure. All right, we can go off the record. Here's the thing I want to let you know, just a second. I want to let you know that I appreciate the fact that you entered a plea to this, you entered a plea to it early, that when you came before the court, you didn't try to be wishy-washy on whether you did it or not. You are a person who truly took full responsibility for what you did. And I appreciate that you did that.
The kids have decided that they wanted to say something to you. Our daughter states that, to me, you were never really my father, only because you treated me like I was nothing, for always lying and never listening when I told you the truth, for robbing me of my childhood and making me have to grow up too quickly.
All right, excuse me. I'm so sorry. The defense has raised an objection. I'm going to sustain that objection. Thank you so much for coming in to give your statements.
Thank you.
All right, thank you. All right, thank you. All right, Amber Salazar.